Hi, my name is Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to continue from episode 31 to further arm our audience with knowledge of how to lawfully exercise and utilize your rights under the U.S. Constitution during these troubling but temporary times. Today, we're going to discuss what to do if police or ICE come to your workplace or business. The Fourth Amendment states, quote, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." Generally, police and ICE may enter places of business that are open to the general public without any prior authorization. However, police and ICE are not allowed to enter places of the premises that are not open to the public, like a back office, employee break room, employee-only restrooms, kitchens, employee locker rooms, etc. Make sure that you take your phone and film the encounter, but do not obstruct the officers from their lawful conduct. Filming police and ICE while they are engaged in their duties or acting under color of law is conduct that is protected by the First Amendment of the U.S. Constitution. Further, the police or ICE cannot make you delete the contents of your phone or search the contents of your phone without your permission or a valid search warrant issued by a magistrate or a judge. Never let them review the contents of your phone or allow them to delete the contents of your phone. Additionally, send a text or email to your attorney that the police or ICE are at your workplace or business. Whatever you do, do not run or get violent or make threats of violence against the police or ICE. If you run or physically fight, they will have probable cause to seize you. Finally, shut your mouth and do not answer any questions that the police or ICE may ask you. Nothing. Simply, but respectfully state, "Officer, I do not wish to answer any questions until I speak with a lawyer pursuant to my Fifth and Sixth Amendment rights under the U.S. Constitution." Then ask, "Am I free to go?" If they say you're free to go, walk away. If they say you're being detained, do not walk away, but respectfully ask, "Officer, what crime am I suspected of committing?" The police must have specific, articulable, objective facts to point to before they may detain you. Make sure to record this exchange if possible, and at a minimum, try to have a non-police or non-ICE person present as a witness, and get their name and contact information if you don't already have that. The Fifth Amendment of the U.S. Constitution states in part, quote, "No person shall be compelled in any criminal case to be a witness against himself. This means that the government does not have the authority to make you answer questions that may incriminate yourself. If the police or ICE have a valid search warrant to search your workplace or business that is issued by a neutral and detached magistrate or judge that specifically authorizes the police or ICE to search the employee-only areas of the premises for things such as prohibited contraband or individuals named to be seized and arrested, they may search. Beware, a Form I-200 U.S. Department of Homeland Security warrant for arrest of alien or similar document is not a valid warrant because it is not issued by a neutral and detached judge or magistrate through a court of the judicial branch. In other words, by the judicial branch and not the executive branch. This is a vital check and balance as part of our constitutional system. If the police or ICE have a valid judge or magistrate issued warrant from a court, which should have a caption of the court at the top of the first page, and it should have a judicial signature on the page, you must permit them to conduct a search as prescribed in the warrant. No more, no less. As a non-ICE related example, if the police are searching a home or a place of business for a shotgun that is named in a valid warrant, perhaps because it's alleged to have been utilized in a crime, they cannot search areas where a shotgun could not fit, like a medicine cabinet or a drawer, unless they have other items in the search warrant that are specifically named that could fit in those places. In other words, police and ICE cannot search areas that could not possibly contain items or persons to be seized in the warrant. As another example, if ICE comes with a valid arrest warrant to be executed at your workplace or business for a named individual, they cannot search for places where that individual could not possibly be located, like in desk drawers or on computer files. Also, know that any contraband that is in plain view may be seized by the police in addition to whatever they are searching for, provided that they locate what they're searching for. If, for example, if you have a bag of drugs out, illegal drugs out on the counter while they're searching for something else, it's in plain view, it's fair game to be seized by the police. You may observe the police or ICE conduct their search pursuant to a validly issued warrant, but keep your distance and do not obstruct their search or make any physical contact with them. If the police or ICE do not have a valid judge or magistrate issued search or arrest warrant naming the specific location to be searched and the items or persons to be seized, do not consent to a search of the non-public areas of the business or workplace. If you say no to a search, they will generally need to come back with a warrant signed by a judge or magistrate to conduct the search, which is based upon the judge or magistrate's independent, detached finding of probable cause. Again, if the police or ICE attempt to ask you questions, respectfully decline to answer any questions. If you or a coworker or employee are seized, they should assert that they will not answer any questions until they have spoken with an attorney, as you should do the same. The Sixth Amendment of the U.S. Constitution states in part, quote, "In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. This means that you have the right to speak with an attorney before answering any questions from the police or ICE. If the police or ICE force their way into your workplace or business, do not resist. Tell everyone in the business or workplace to remain silent and don't answer any questions until they have had the opportunity to speak with a lawyer. You have the right to remain silent. You do not have to discuss anything with them, including your immigration status, whether you're a U.S. citizen, or anything else for that matter. If you have valid immigration documents, you should show them. If you are arrested, say that you wish to speak to a lawyer before answering any questions. Never present any false documents and never lie to them. After making that clear, police or ICE should honor that request. They cannot compel you to say anything once you have invoked your right to remain silent and state that you want to speak with an attorney before speaking with them. Immediately contact an attorney as soon as possible if you believe your rights have been violated by a government official. If a state or local official violates your constitutional rights, you may have a claim where you could recover damages under 42 United States Code 1983, titled Civil Action for Deprivation of Rights. If a federal official violates your constitutional rights, you may have a claim where you could recover damages, which is called a Bivens claim, under the 1973 U.S. Supreme Court precedent from a case named Bivens versus 6 unknown agents. Keep following Executive Coup for further updates on this matter and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. Thank you.